Clerk will report the title of the bill.
H.R. 4194, a bill to amend Title 18 United States Code to exempt qualifying law school students participating in legal clinics or externships from application of the conflict of interest rules under Section 205 of such title.
Pursuant to the rule, the gentleman from Tennessee, Mr. Cohen, and the gentleman from California, Mr. Lundgren, each will control 20 minutes. The chair recognizes the gentleman from Tennessee.
I ask unanimous consent that all members have 5 days to revise and extend their remarks and include extraneous material on the bill under consideration.
Without objection.
And I yield myself such time as I may consume.
Gentleman is recognized.
Thank you, Mr. Speaker. H.R. 4194 would address an unfortunate consequence of current law that hinders participation by law students in pro bono clinics, which limits the provisions of those needed services to the community. It's appropriate that this resolution follow that of Justice Brandeis, who really was the father of pro bono work. Title 18 U.S.C. 205 makes it a crime for a federal government employee to provide legal assistance to anyone in bringing a case against the United States or in bringing a case adverse to a substantial U.S. interest. Section 205B applies the same rule to employees of the District of Columbia. For law school students or legal clinic staff who hold government jobs, this criminalizes participation in a wide range of clinical programs, including those funded by the federal government. Law students or legal clinic staff who are full or part-time government employees face criminal penalties if they participate in law school pro bono clinics that represent plaintiffs whose claims are adverse to the federal or D.C. governments. Yet this opportunity is important for students to learn their craft and become lawyers. This disqualifies the law students from participation in these many activities that benefit the wider community as well as the student, among them juvenile justice clinics, death penalty appeal projects, advocacy programs on behalf of parents with special needs children, and low-income taxpayer clinics. This also has the perverse effect of forcing law students to choose between government service and community service. It also needlessly deprives government employees of a range of real-world educational experience that would be particularly beneficial to them when they become lawyers. Just this year, this Congress passed the Edward Kennedy Service Act, encouraging people to participate in public service, and this is another area where we should encourage it. This is a misguided choice to force on law students, for they should be able to have both government and community service, and encourage so. This bill will stop the law from forcing them to have this conflict. Section 205 already contains an exemption that narrows the definition of conflict of interest to those instances of actual conflict. Cases in which government attorney substantially and personally participated as a government employee, or cases in which the employee's department or agency is currently directly participating. By applying this exemption to law students and legal clinic staff, the bill will eliminate the pernicious effects of Section 205 while retaining safeguards against true conflicts of interest. Law students and legal clinic staff will be able to participate in law school clinics that are by their nature adverse to the federal or D.C. government, while continuing to prohibit actual conflicts of interest involving specific parties. Law students and staff who choose government service would remain subject to a governmental conflict of interest rules, while also being permitted to enjoy the same clinical resources and opportunities as their peers. I commend our colleague, Congressman Dan Lundgren of California, for his leadership on this important bill, and I urge my colleagues to support it. I reserve the balance of my time.
Gentleman reserves. Gentleman from California.
Thank you, Mr. Speaker. I yield myself such time as I may consume.
Gentleman's recognized.
H.R. 4194, the Law Student Clinic Participation Act of 2009, makes a simple yet important change to federal law as to increase law students' access to clinics and other law school programs. Nearly 44,000 law students nationwide will graduate this year from more than 200 law schools across this country. During their time in school, each of these students will study property, criminal, constitutional, and contract law, just to name a few. And these classes not only instruct the students on the relevant case law or statutes, but also attempt to teach them how to think like a lawyer, that is, to analyze cases from a lawyer's perspective. As important as that is, equally important are the clinical programs offered by virtually every law school in the country that teach students how to practice law. Clinical programs include prosecution and defense, appellate advocacy, including death penalty appeals projects, juvenile justice, and even tax assistance clinics. Yet a little-known provision in federal criminal law, that is, it makes it a crime, prevents certain law students from participating in these clinics. In other words, they would be subject to criminal penalties if they participated in these clinics. That is because Section 205 of Title 18 prescribes criminal penalties for government employees who provide outside legal assistance in a case against the United States or adverse to a substantial U.S. interest. Therefore, law school students or even staff who are also employed by the federal government, full-time or part-time, may be barred from participating in these valuable clinical programs. The impact of this provision is perhaps no greater than right here in Washington, D.C., in our Washington, D.C. metropolitan area, which is the home to over a half a dozen law schools. It comes as no surprise that many of these schools' students are also federal government employees. Some of the schools have night programs, so the students work full-time during the day and take classes at night. Many times they do work for the federal government or the D.C. government. But because of their employment, they are therefore disqualified from participating in these extremely beneficial programs. This was most certainly not Congress's intent when it enacted Section 205. H.R. 4194 remedies this problem by extending an existing exemption within the statute to include federal employee law students. The bill therefore appropriately allows students and staff to participate in clinics, including those that are adverse to the federal or D.C. governments. However, and this is important, the bill continues to prohibit any actual conflict of interest involving specific parties. Therefore, if the student or staff member is involved in a matter which would be a direct conflict of interest, they are not covered by this waiver. It would seem that this is a common sense solution to provide those students employed by the government the same opportunities as other students. I might say, Mr. Speaker, when this came to my attention, I thought that perhaps we could have a relatively simple, straightforward waiver or exemption to take care of this problem, which was unanticipated by the Congress when it passed the relevant law. And therefore, I would urge my colleagues to join me in supporting this bill. And if the gentleman from Tennessee has no other speakers, I would yield back the balance of my time.
Mr. Speaker, we have no further speakers.
Gentleman yields back. Gentleman from Tennessee.
Mr. Speaker, I just want to thank Mr. Lundgren for bringing this to us. It is important that the law students do have this opportunity and that the conflicts be real and not imagined. Would like to encourage a yes vote and would move that we pass the resolution at this time. I yield back the balance of my time.
Gentleman yields back. All time has expired. The question